Michigan Board of State Canvassers. Director Brader, has the meeting been properly noticed?
Yes.
Thank
Yes.
you. The first order of business on the agenda is public comment. And this would be public comment which is not specifically directed to other items.
Can't hear you.
Can't hear you.
Oh, okay. Turn on my mic. Okay. Thank you. Has anyone indicated a desire to speak?
Mr. Gallant has, and I believe he is on Zoom.
Mr. Gallant, can you hear us?
Yes, can you hear me now?
We can. You have 2 minutes.
Okay, thank you very much.
Mr. Fracassi is timing you.
Okay, thanks, Adam. Be good to me, be gentle, okay? Coalition, these are my opinions. I'm still waiting for the AG opinion concerning Robert's rules being required by public bodies in Michigan as it was determined by Mike Brady, the Director of Legal Services, on September 17, 2020 for the Independent Redistricting Commission. It's in the transcript, including the chapters on the Secretary and the Chair and the Parliamentary Law. All apply here. And you were going to get us an AG opinion, and I haven't got that back on their listserv. They say new opinions come out on the listserv. So please schedule a public hearing to approve the language for that request from this board to the Attorney General, and then you could give us a chance to, get some input. And I believe the petitioners today here have a right for the commissioners to understand the question before them. You don't have a question before them. It's consideration for something. No. Under Robert's Rules of Order, and Jonathan Brader has already determined, it needs to be a specific yes or no question before you. And that's page 3666, line 8. No debate before motion second. Okay, so the question is that's on the agenda. It should be approval of the petition as sufficient. Yes or no? If you disagree, vote no. That's supposed to be the question. Whoever wrote this agenda, this doesn't comply with Robert's Rules of Order. So by example, yesterday at the Independent Citizen Redistricting, Commissioner Eads stopped the mapping, suggesting that we change the numbering for like 20 minutes. And then the lady said, well, Madam Chair, I call the question. So Commissioner Eads said immediately, there is no question. So exactly. So that's a violation of our parliamentary common law in America. You have to have one question at a time. And your statements need to be germane to that immediately pending question. That's what you're here to do. That's your job, your duty, your responsibility in the Constitution. So please get us that Attorney General opinion so we can settle this in our communities. This is what's destroying the fabric of our community is interpretation of Robert's rules. And you say, well, long-standing, for decades, you've been hiding behind this. Well, it doesn't necessarily apply. Well, we need to find does it or does it not. Because if it does, then you need to change your position and how you do the business here. Because Robert's Rules is the highest ethical standards of business practices in the United States. Because it's determined under our Constitution. It's a directive, interpretation of our Constitution. So that's how it works in our society. That's how it works. So please help. Please help us here. Can you do that for us, Madam Chair?
Thank you, Mr. Gallant.
Thank you.
The next item on the agenda is consideration of the meeting minutes for the December 18th, 2023 meeting. Do we have a motion?
Madam Chair, I make a motion to approve the minutes of the Michigan Board of State Canvassers meeting on December 18th, 2023.
Support.
All in favor? Aye. Motion carries. The next item is consideration of the sufficiency of the recall petition submitted by Governor Gretchen Whitmer. Mr. Trebilcock has indicated that he wishes to speak to this issue. Mr. Trebilcock?
Yes. You ready?
Yes.
Sorry.
We have not heard, we do not have any indication that Mr. Bassi wants to speak to this matter.
I didn't know I could participate by Zoom. That would have saved me some time this morning.
Wait 1 minute. Okay. Mr. Trebilcock?
Good morning. Great to see you guys
Now,
again.
let me just remind you and others that we have carefully read your position letter, and we have a lot of items on the agenda.
Yes, ma'am. Good morning. Mr. Fracassi just handed me something that apparently Mr. Bassi sent in, which appears to be something from a website from City of Albion saying that he is registered. I'd like to just present to the link that I had sent, but my understanding is that some of you weren't able to obtain it. This is the voter registration from San Diego County Registrar of Voters, indicating that on June 5th of 2023, Mr. Bassi registered in San Diego County. And so Mr. Bassi trying to assert that he can vote here in Michigan and also vote in California is either perpetrating a fraud on the state of California or he's perpetrating a fraud here on the state of Michigan.
Let me interrupt you for 1 minute. Member Bradshaw has indicated that we should read into the record the language that Mr. Bassi has submitted before we hear your comments about it. So let me do that. The language on his recall petition is as follows. Governor Gretchen Whitmer has budgeted funding for law enforcement throughout Michigan that enforce Michigan statutes that have similarities to slave licensing, flat codes, and Jim Crow laws without adequate safeguards to prevent from discrimination against low-income individuals and communities, echoing the behavior of slave traders against those of color. Petition. The second is Governor Gretchen Whitmer has had direction over the Michigan Department of Agriculture, which licenses immigrant labor camps but denies many of the immigrants a driver's license, which can entrap foreigners.
Thank you. Thank you, Madam Chair. And I will not repeat the arguments and certainly refer to them in our response on the failure to meet the standards under the election law on why those two reasons that you state lack sufficient clarity and fail to meet the standards under the recall statute. We detailed those therein, and I trust that you understand and happy to answer any questions you may have. But I do want to focus on the preliminary issue of whether Mr. Bassi is even eligible and qualified to be able to submit a recall petition in the state of Michigan to begin with. And as they like to say, it's best to start at the beginning. You may be familiar with that. I believe Winnie the Pooh says that. Article 2, Section 8 recalls in the state constitution. Laws shall be enacted to provide for the recall of all elected officers except judges of, and here's the key phrase, petition of electors. Petition of electors. That's Article 2, Section 8. To Section 1, qualifications of electors. So under our Constitution, to petition a recall, you have to be an elector, and our Constitution defines what the qualifications to be an elector are. And those qualifications are, you have to be a citizen of the United States, and the text of our Constitution says age 21. That has been superseded by the U.S. Constitution that says you have to be 18, who has resided in this state 6 months, and who meets the requirements of local residence, again, that term residence and resided, provided by law, shall be an elector and qualified to vote in any election except as otherwise provided in this Constitution. The legislature shall define residence for voting purposes. So again, to be qualified to submit a petition to recall an elected officer of this state, you need to be a qualified elector. So, qualified elector, echoing the Constitution, MCL 168.10 defines qualified elector, Article 2, Section 1, which I just read, as well as you have to have resided in the city or township that you live in for at least 30 days. MCL 168.11, as directed by the Constitution, defines what it means to be a resident and have residence. It's where you habitually sleep. It's where you keep your personal effects. It's your place of lodging. It is where, and the case law is interpreted to this to say, it is where you, even if you leave, it is where you intend to return. Now, talking about registration, to be able to register to vote, MCL 168.492 says you have to be a resident of the state and a resident of the township. Again, you have to be the place where you habitually sleep and keep your personal effects. We've provided evidence to this board that Mr. Bassi is a resident and lives in Tijuana, Mexico. He's not even doesn't even live in this country, and is a resident of Tijuana and is registered to vote in the state of California. We have provided you the official printout of his voter registration. We have provided a news article with a photograph of Mr. Bassi where he is quoted by the news as stating that he lives in Tijuana and commutes to San Diego. That is sufficient evidence for this board to deny and conclude that Mr. Bassi is not a qualified elector as required by our Constitution and the Election Code. Now, you may have heard, and you may say, well, hey, he submitted this piece of paper that says he's on the voter polls here in Michigan. You may have heard from the Director of Elections that, well, he's still on our poll book because of the National Voter Registration Act and the Help America Votes Act. Well, that's a red herring. Does that matter? No. Because the National Registration Act and the Voter Registration Act, by its terms, applies to qualifications for federal elections. It does not govern and supersede our Michigan Constitution. To hold otherwise would say we're beholden to what the federal government says about our recall petitions. And say that his voter registration is a factor to consider. MCL 168.505 allows our Bureau of Elections to cancel a voter registration. How do you do it? Two ways. Authorization signed by the elector and received from the other state in which the person is registered, or two, notice from an election official of another state that the elector registered in that state. In this case, you have notice from the San Diego Register of Voters. I have provided you with that notice. It is their official website. And not only that, I provided the Bureau and this board more than 2 business days ago this notice. There is no reason that this board or the Bureau could not have picked up the phone and called the San Diego Register of Voters and said, hey, we received information that a Chad Everett Bassi, previously registered in the state of Michigan, has registered June 5th, 2023, attesting under penalty of perjury that he resides in the state of California and has registered to vote. Is that correct? And if they would have said yes, then we would remove him from our polls. I don't know if that has occurred or not, but this board has notice from the official San Diego County Board of Electors, or Register of Electors, that Mr. Bassi is a resident of California and is registered to vote in the state of California. Now, the state of California law requires that Mr. Bassi, when he registered, inform the state he's registered in another jurisdiction. He has to affirm under penalty of perjury that he is a resident of the jurisdiction that he is registering in, and he certifies under penalty of perjury that that is all. Chapter 2, California Election Code, Section 2150. Chapter 4, California Election Code, Section 349, defines what residence is. It mirrors Michigan's, that it is the place where you habitually sleep, keep your belongings, intend to return, all those things. The law is almost identical. Here, the election official of San Diego County on its official website states that Bassi registered to vote on June 5th, 2023. He swore under the penalty of perjury that his residence was in California, in San Diego County, and he also listed, and it's required on the form, and I have it if you want to see it, previously registered. It's required under California law. And at that point in time, he was no longer a qualified elector under our Constitution. And therefore, he cannot initiate a reconstitution. Where do we start? We start at the beginning. The Constitution. The Constitution is what gives us the right to recall in this state. The Constitution requires you to be a qualified elector. The Constitution defines what a qualified elector is, and Mr. Bossi, at the time he submitted this recall petition, was not a qualified elector. Moreover, this Bureau and this board has been provided sufficient information to remove Mr. Bossi from the voter registration polls, therefore furthering evidence that he is not a qualified elector and cannot submit a petition under the Constitution or the laws of this state. Therefore, we would urge this board to follow our Constitution and declare that Mr. Bossi is ineligible to submit a recall petition until he reestablishes residency in the state of Michigan and re-registers and confirms that with the Bureau of Elections. Thank you.
Questions?
So the information about, registered in California, we get this piece of paper, it looks like it's just January 19th at
9:13.
Thank you.
You're welcome.
Man, I should have brought my readers.
Get longer arms.
So even if he did register and he's reestablishing, the issue you raised about, I heard you mention 30 days and 6 months. So
Correct.
regardless of, argument still holds that it's invalid.
Correct. The voter registration, I think, is a red herring issue. That, whether you're still on the polls or not, that's required by the Help America Votes Act and the National Registration Act. And there's specific guardrails so that people aren't improperly removed from the polls. Now, what that permits under the statute is if our Bureau gets notice and written authorization from the voter, hey, I've registered down in Ohio, take me on, get that, or the Bureau of Elections, some states require it. Michigan, as part of your registration process, and they can correct me if I'm wrong, you sign an authorization that says you're to notify the other state that you're now registered in Michigan. I dug as much as I could. California obtains that information. I couldn't find anything, at least in the statutes, maybe there's a policy or procedure I couldn't locate, that affirmatively requires them. I'm not sure if the Bureau received notice independently last June or since June. But as of today, Mr. Bossi, and from all knowledge that we have, lives in Tijuana, is a registered elector. His last voter registration is in California, San Diego County. That's one piece. But all evidence that we have, and I can provide it, his Facebook page lists that he lives in Tijuana. All his pictures are talking about being in Southern California and Tijuana. He is not a resident in this state, and he is not a qualified elector under the Constitution. That's the standard. This board is charged with the national voter registration, whether he's on our polls or not. That's a separate issue. Whether he's properly removed. The issue before this board is the Constitution. And the Constitution requires you to be a qualified elector. And we've provided evidence that he is not a qualified elector because he's registered and resides in another state.
This isn't some instance where there's another Chad Bossi who just happens to share a name and you're confusing him. This is crystal clear.
What I submitted to you is Chad Everett Bossi, date of birth, I believe it's July 18th, 1980. To refute any of those questions is why we submitted the news article that includes a picture of Mr. Bossi that matches Mr. Bossi's Department of Corrections booking photo for when he was imprisoned. They're identical, so I don't believe there's any question that Mr. Bossi living in Tijuana and residing in the state of California is any different than the one that used to be here in Michigan.
I did also compare Mr. Bazzi's Department of Corrections photo to the one in the news article which you sent. But it's my understanding that Michigan law, in order to cancel a voter's registration, is essentially compliant with the National Voter Registration Act. And while I think that Mr. Bazzi may have a serious problem in California if he didn't indicate that he wished to terminate his Michigan registration, because he could have, I know in compliance with Michigan election law, when one changes one's registration or goes to register in a different jurisdiction, one can authorize and is expected to authorize cancellation of a previous registration. And you indicate that that is the case in California as well, but there has been nothing sent from California, so far as I know, to indicate that Mr. Bazzi has authorized the cancellation of his Michigan registration, and in fact it appears to be still existent. So I don't, my legal opinion here, but my opinion is that so long as his registration is not canceled, he's registered in Michigan. He may have serious problems in California. I hope he does, but I don't think we can find that he's not a registered voter. I understand what you're saying, that you're saying he's not qualified to be a registered voter any longer, but he's still a registered voter.
Let me refute and push back on your legal analysis in two parts. One is, as you note, the standard under the Constitution is not, is he a registered voter under the National Registration Act. That's not, the standard is he a qualified elector, and you have to look at that definition. And his voter registration is but one piece of evidence to determine whether or not when he submitted this petition, is he a qualified elector. And second, I think you forgot a piece under the federal law as well as under state law. It's not just that Mr. Bazzi authorizes his removal. It is as if this Bureau receives notice from another election official. Notice is not defined in the federal law, and it's not defined under Michigan law. You have notice, and you've had notice for 3 business days. If there was any question about whether or not Mr. Bazzi, because I've provided the official printout from the San Diego County.gov website confirming Mr. Bazzi's registration, this Bureau now has notice from the San Diego election official that Mr. Bazzi is registered in another state. Now, if there's any question of that, the Bureau could have taken the time to pick up the phone and confirm that, and then the notice would have been received. There's nothing in the statute that says it has to be sent by certified mail, it has to be faxed. It says notice. And notice has been provided from the official San Diego County Register. So, if, in your opinion, voter registration is what is determinative, then I would say it's not valid. But let's just take for consider a moment, Michigan law is clear that we're not to interpret statutes or the Constitution that reach absurd results. To take your conclusion that says, look, if you're on our voter polls, you can recall our elected officials. The only way you get removed automatically from the voter polls is if you don't vote in 2 federal elections and then don't respond to a card that we mail you. That's at least 4.5 years. So I can move to Alaska, register to vote in Alaska, vote in Alaska, and sit in Alaska and try to recall elected officials in Michigan for 4.5 years. That is an absurd result. That is an absurd interpretation of our Constitution and the Michigan election law. And in this case, I don't understand why we're bending over backwards when we've got documentary evidence that the man is registered to vote in California and lives in California.
I don't understand the information that you provided to us to constitute official notice from California that he has authorized the cancellation. I mean, so far as I understand, the state of Michigan, and particularly the clerk of Albion, where he is registered, has not received any notice from California.
Did you confirm that with the clerk from Albion?
The clerk from, I asked Mr. Fracassi whether Mr. Bassi was still registered, and he confirmed, as he did with you, that he is still registered. And, that has been confirmed. But my concern is for the voters. And I understand your concern that Mr. Bassi, Tijuana, and trying to recall Governor Whitmer, which is it's a difficult circumstance for us to deal with. But his registration is valid until it's canceled in accordance with the National Voter Registration Act, which is also adopted by the state of Michigan. So I think
it's a different standard. I would urge that it's a different standard
and I don't think
that
we
gets
can
applied.
say he's not qualified to be a registered voter if in fact he's a registered voter. That is not a determination that we are able to make.
A qualified elector. It's not registered voter, it's qualified elector. And how that is defined by the Constitution is that you have to reside, residence. And you now have evidence, both from the voter registration and the news article where he states that he lives in Tijuana, that he is no longer a Michigan resident.
Any other questions?
Yes, it's not necessarily related to the residency issue, which I think is, in my mind, beyond compelling. Don't get it over your head that I agree so strongly. So there's in one of the various news articles on Mr. Bassi and his recall efforts, and I'm familiar with him having served on this is now my 4th year, and he's a habitual submitter of these. This article starts out, the Albion man who recently filed his 6th recall petition against Michigan Governor Gretchen Whitmer told the Michigan Advance, the effort is more focused on trying to get his driver's license reinstated than it is about actually gathering signatures and following through with the petition process. My question, whether it's for your interpretation or from our staff here, is that type of statement and information enough for us to reject his submissions because they indicate a lack of seriousness and that they are essentially a nuisance effort? Or is that I'm careening off into an area that maybe we shouldn't consider? So I'll ask for your interpretation, and then from Mr. Rader, kind of what the thinking is.
You sure don't want to hear from him first?
Sure.
Well, I might have to kick it to Mr. Grill in terms of your legal options. But I think that I don't know that there is a specific section of the election law that contemplates the seriousness of the effort. I think it speaks to the reasons for recall, clarity and the factualness of those in the conduct in office. I'm not sure if the motivations of the person are something that is contemplated by the election law. Anything you want to add?
I'm unaware of a case specifically dealing with the motivations of the sponsor, but there are a long line of cases in Michigan going way back, even several versions of the Constitution ago, to the point that the sufficiency of the grounds of recall is not something that should be considered. In the current Constitution itself, the last sentence says that the sufficiency of any statement of reasons or grounds procedurally required should be a political rather than a judicial question. This has long been held to be the idea that it is not for us to decide whether or not the reasons are good reasons or not. It is simply, do the reasons meet the requirements in the current statute? I believe it is clarity and factual.
Because there are a lot of people here who have not dealt with recall before, apart from the issue that you have raised, Mr. Philcock, with regard to Mr. Bassi's residency, what we are required by the statute to find is whether each reason for recall stated in the petition is factual and of sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. And I know that you sent us a position letter saying that in addition to considering whether Mr. Bazzi is a resident qualified elector eligible to file a recall petition, you have said that the petition is not of sufficient clarity. And I think that people need to understand that that's also an issue which we're considering. I think we could find without necessarily addressing I guess the petition, in my opinion, is not clear. I mean, that was evident to me when I read it a week or two ago. And so I think we would find that it is not, I expect that we would find that it is not of sufficient clarity. Can we have some discussion on that?
If I could weigh in on that,
Yes,
I was
please.
waiting for you on that.
Madam Chair, if I could just briefly, I do want to address Mr. Dawn's question, if I could, just briefly, which is, I agree with what Director Brader and Mr. Grill said, that as far as the election law goes, in terms of the seriousness of the effort under the election code, that at least the language is a political question, whether the reasons. However, the Bureau has issued a declaratory ruling where the seriousness of the election effort or recall effort, and whether they're actually gathering signatures, is relevant under the Campaign Finance Act, and whether or not you can go and raise money. And they've used that in part of their determination of whether there is a special election recall period going on for recalled officials. So I do think it's a relevant issue and a relevant question. The Bureau has made it a relevant question through their declaratory ruling on the Campaign Finance Act. But I'm not sure it plays for the issue before, the issue before you today. But just to quickly say, as you recognize, Madam Chair, I think there's multiple reasons in addition to Mr. Bassi not being eligible to file a recall petition. The recall petition lacks sufficient clarity. It is rife with opinions and conclusions and not stated factually. There's also, it's unclear as to what term or when the alleged conduct took place, as well as using several ambiguous terms and phrases that would justify this board rejecting the petition.
It would be in our interest to say that Mr. Bazzi is not eligible to file a petition because he has indicated that he wants to continue to do so and to require us to continue to address the district voter, in my opinion, so he can do it. But do we have any motion?
I wouldn't, I agree that this is, like you, when I first saw it, I said this is not factual or clear in any way. I do, however, have a strong belief that the evidence is pretty overwhelming that he is not qualified to be submitting these. And I would prefer that the rejection be based on that than the actual language. And I'm curious what my other, obviously I know where you are, Madam Chair, but
Is it possible to reject this on the basis, on multiple bases? Is it possible to
When we make the motion, we have to make the motion on why it isn't factual and clear, right? But I think, Tony, where you're going is you'd rather go with the other one so that we're not coming back here again on clarity.
essentially, yeah, because he's clearly not, based on this evidence, he's clearly not qualified to submit these.
If I might make a suggestion, perhaps two motions, one on the clarity issue and one on the eligibility.
Madam Chair, I'd like to ask, if the second one is legal counsel. Sorry, Eric.
So the question, I think, if I can help, I think the question is, can does the board have authority, or can the board approve a motion to reject or dismiss the recall language on the basis that the individual who filed it is not a qualified elector in Michigan?
Kind of nested, I think, within that is the suggestion that the board, I think, make a series of determinations. First, that Mr. Bazzi is registered in the state of California. Second, that his registration in the state of Michigan is improper. That Mr. Bazzi's registration, he is not an eligible voter in the state of Michigan. And then lastly, as a consequence thereof, that he is not able to submit a recall petition, and that this board then has the authority to reject it on that grounds. I have not found any statutory authority suggesting that this board can cancel the registration.
I would just say again, I'm not asking this board to cancel Mr. Bassi's voter registration. The determination is you go back to the beginning. What does the Constitution say to be an eligible person to petition a recall? It's an elector. The Constitution defines what is a qualified elector, and Mr. Bassi does not meet the definition of a qualified elector. He may still remain on the voter polls and not be a qualified elector. He could be challenged if he tried to vote here in Michigan as not being eligible. There's processes and procedures for that. That is not what I'm suggesting the board do. And I would again say, if this board doesn't have the authority to make that determination in regards to recall petition, does it? So this board is just going to consider if Joe Schmo in North Dakota submits a recall petition, who screens that? Who makes the determination? Who makes the decision? And who gets to appeal that decision? And when does that notice go out? I've never received, and I've handled many recall petitions, both before this board and locally. At the local level, a submission that certifies they are a registered elector in that district, that they're eligible. Because remember, on the local level, it's not just whether you're a registered voter. You have to be a registered voter in that jurisdiction of the officer you're trying to recall. In this case, it just happens to be statewide. So, you make the determination and you go by voter registration. What if the person hadn't changed their registration, and they actually live in Grand Rapids, they've lived there forever, and they're just voting absentee from Royal Oak. And they can therefore recall people in Royal Oak to their heart's content? That's not the standard.
So you're saying that in local jurisdictions, the voter is required to sign that they are a registered voter in that jurisdiction?
The local clerks...
But not that they are qualified and registered voter in that jurisdiction.
I believe it's qualified and registered. They're a qualified, registered elector in this jurisdiction. The standard is a constitutional one, not a voter registration one.
And what I think, Mr. Brill has answered our question, but I'm not, the question posed by Mr. Hauskamp, that is whether an issue before us is whether he is a qualified voter, even though he is, you're suggesting he's a qualified elector in the state of Michigan, and whether we could reject his petition on that basis. So Mr. Brill has suggested that that is not a basis for rejecting a recall petition, is that? I'm not sure if you waffled a little bit.
I smell waffle.
If I could try to buy Mr. Grill some time. But I mean, just the way I can't give you the legal answer of that. But practically speaking, the screening that we do is we check to see if they're registered to vote. I don't, and nobody at the Bureau of Elections has the ability to know in real time whether anybody is at this moment a qualified elector in Michigan. We don't know if yesterday they moved to another state and that data hasn't come to us yet. So we use the qualified voter file because that's the only practical tool we have to tell if somebody is qualified here, if they're registered to vote here. It's certainly true that for many individuals, they may have physically relocated to another state, and there may be a lag time as required by both state and federal law before we can cancel their registration. There are ways where we can immediately cancel a registration if the individual themselves, they contact us or their clerk and they want the registration canceled. Another state can give that information to us, but for it to be an immediate cancellation, we don't just, the registration form they signed, we need to see their signature because we need to make sure that that person actually authorized the cancellation to immediate, and then it's the same person, not someone with a similar name, before it can immediately cancel. Otherwise, if it comes to us in the form of a sort of a printout or data that appears to be the same person, what that falls into is the category of reliable information that the individual has changed residency out of state rather than authorization to cancel. And in that case, we inactivate them, but they don't get canceled until 2 federal elections pass, unless they tell us they want to be canceled. There is a method where an individual citizen can also challenge registration, but that has to be done before the individual's clerk, and it has to be with a signed, notarized affidavit that indicates why they believe the person is not qualified. So I agree with Mr. Philcott that there is definitely a difference between whether someone's registered to vote here and whether they're at this moment a qualified elector. I don't think we have any practical ability, though, to screen the qualified elector question in real time. Whether the board can make that factual determination or whether it has to be a court is not something I can answer for you. I can defer to Eric, who can do his best to summarize what we have on that.
If I could buy Mr. Grill a little more time, if you want.
I think if there would be, some distinction if there were a situation where it was clear that the individual submitting the petition was not in fact a registered voter. That if the staff had conducted an investigation and determined that they're not in the QBF, that might be one thing. But the situation we have here is that the individual is in the QBF, and the request is basically for this board to determine that that is incorrect. And that's where I think we have, the gray zone and the problem here is what is the authority for the board to countermand or override that determination. There is a statutory process for determining whether or not an individual should not be an eligible voter. I think that's usually handled by the local clerk's office.
If I can make 2 points. One is, the Bureau of Elections has had this information for 2 days, and Mr. Brader just said that, when they get information, they can contact the other states' register of electors and see the card and request that stuff. I suggest that that should happen, and perhaps it has happened. I don't know, but perhaps it should have happened, respectfully. And I would say, second, determinations on residency happen all the time. When you challenge whether or not somebody's qualified to run in a certain office, that gets challenged and determined at the trial court level all the time. In this case, this board is serving as a quasi-trial court, and if the decision you reach is wrong, Mr. Bossi has the ability to appeal your decision to the Court of Claims or the Court of Appeals, just like a determination at the trial court. So I would argue that we have provided sufficient evidence for this board to conclude, based on the evidence, that Mr. Bossi is not a qualified elector based on his residence being in California.
I think there is at the front. I'm sorry.
Mr. Grill, you had.
It does occur to me that there is a problem with that if this board were to make that determination that Mr. Bossi is not an actual qualified voter, that doesn't itself have any consequential effects with his registration status in the QBF or his registration with the local clerk's office. There would still have to be additional steps taken for that registration status to be changed. So it presents at least the problem that this board's determination would be in conflict with state records.
Mr. Houskett?
I guess I listen to all your arguments, but I have one underlying piece here, and that is that to go with what you're saying, in effect, you're turning this board into an investigative unit against somebody who's a voter of the state of Michigan. And I get really, that to me would be reason to not go with your argument. Because if we go with your argument, in effect what happens is that means anybody that comes to us with a petition or anybody that comes to us with business to conduct, you're opening up a door where we can now start to investigate that individual to see whether they're worthy to even come in here. And I think that that's not our mission.
I think in the standards here, you are the gatekeepers of access to the ballot, and the Constitution sets those standards. And working with the Bureau, we have deadlines as part parties challenging the petition, both the content and the ability to assert such a petition, that 2-3 days ago, that says this individual is registered in California and shouldn't be eligible to submit this. So you can, that is a very ministerial function to verify and request that comparing signatures. This board has the authority, and matter of fact required, to compare signatures many times in various parts of the statute. So I don't think it's opening the door. Rather, I think the floodgate you're opening is that every Tom, Dick, and Harry across this country that's got a beef with some Michigan election official is going to flood this board with recall petitions.
I don't think we have a lot of Tom, Dick, and Harrys who are registered in other states who are filing petitions to recall Michigan officials. I
We shall see.
understand you can say that, and Mr. Bazzi may be inclined to continue this effort. His driver's license, he concedes that. His driver's license was revoked because of a number of driving under the influence infractions, for which he was also imprisoned. Mr. Bazzi is a problematic character, but I don't think that we have the authority to say that he is not able to file a recall petition. He may intend to return to Michigan, in which case thoroughly relocate. And I understand that he registered to vote in Michigan, or excuse me, in California. People can temporarily relocate to another jurisdiction with intention to return, and then they return or even seek an absentee ballot.
So during that period of time, you can still submit recall petitions
You are
in the state of California?
advocate, but we have a very long agenda, so I think it's time to come up with questions.
If you wanted to take that argument, save it for one that comes in that's got a little more walls to it. I know what you've submitted. And
I don't avoid difficult questions, and I think I understand that this is something new and different that this board hasn't faced before, but it's a conclusion, and I would urge you to follow that right conclusion.
And I think that Mr. Housekamp is correct, that we don't need to reach this difficult issue because we can reject the petition on an easier ground. And he is correct that if Mr. Bazzi comes back with something that appears to be clear, if he's capable of doing that, then we might then face the issue which you're raising. Did you want to make a motion?
I believe that I'm much more firmly in line with Mr. Trevilcock's thinking, and I don't want to make a futile motion when we have, I think, unanimous agreement on the factual and clarity issue, and so I don't know if making a motion for me makes the most sense.
Do we have a motion on the issue of clarity, which is properly before us?
Trying to get my words here, because when we first started doing recalls, you could just say that it wasn't factual and it wasn't clear.
Sorry.
Oh, it's okay. I've been here long enough that you are correct that the last thing that you just brought to us is new. And having been here for 10 years, yes, constantly. So for this one, I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad Bossie against Governor Gretchen Whitmer on January 2nd, 2024 are not factual and sufficiently clear because it does not state when the budget happened. There's a couple, and goes to opinion and not fact.
I'll second.
Motion has been made and seconded. All in favor?
Aye.
Motion carries, and the petition to recall Governor Whitmer is rejected.
Thank you, and thank you for entertaining my legal arguments.
Mr. Vilcock. Mr. Bazzi wants to give you a lot of work.
Madam Chair, may I ask just a question? So, and I think that just going back to when we started these petitions, we were, not really all of them, I'm thinking back to the ones from Mr. Bassi, we were under the rule for, under remote. Right. So Mr. Bassi has the right and can send his comments via email to the Bureau, correct?
Yes.
Okay. So he could have stated, however, his case instead of just sending us a email of that he's registered voter in the state of Michigan.
Yes.
Okay. I just wanted to make sure. I know we have to talk about this the next time because we have another one. But the other question I have for Director Brader is, if the Bureau, after someone submits a recall petition, finds that that individual, after the time that the petition is submitted to the Bureau before, and remind everyone, what is the time frame that we have to meet after a recall petition is submitted?
10 to 20 days.
10 to 20 days. If the Bureau finds in that 10 to 20 days that that individual isn't a qualified elector, the Bureau would pull those petitions, or what would be the process?
I don't think we wouldn't put it on the agenda. I don't think we've had that happen since the clarity and factual statute was passed, at least not in my time. Have we? Maybe I'm wrong. Well, in any case, the answer is we wouldn't put it on the agenda. We would notify the board, but we wouldn't put it on the agenda.
Thank you. Okay, the next item on the agenda is consideration of the sufficiency of the recall petition submitted by Chad Bossie against Secretary of State Jocelyn Benson. The petition reads as follows. Michigan Secretary of State Jocelyn Benson, in her current term, has enforced MCL 257.904, even though it has similar effects to slave licensing that put restrictions on movement, acts to create subordination, and has potential for abuse. It likewise is similar to black codes due to vagueness, discriminatory application, and chilling effects on speech and conduct. Also similar to Jim Crow laws, as it creates an environment of economic discrimination, disenfranchisement, and social control. And another reason, separate reason, Jocelyn Benson procures half Michigan license plates sold with laborers paid 45 cents per hour. And for information purposes for people here, I would add that MCL 257.904 is the motor vehicle code. Jeffrey Aronoff has asked to speak to this issue.
Good morning, Madam Chair, members of the board. I'm going to try to read the room a little bit here and keep this very short. Better? Okay. Try to keep this very short. You have our letter. I'm Jeff Aronoff from Miller Canfield on behalf of Secretary Benson. And seeing that you found the prior submission by Mr. Bossi for the recall for the governor to be non-factual or clear, and significant overlap in terms of there being statements rife with opinion and kind of these editorial connections. I'm not going to go into much detail in our arguments at all. I will make one and the prior recall petition that was considered. As Madam Chair pointed out, this is the motor vehicle code, specifically the provisions relating to operating without an operator's or chauffeur's license or an unregistered vehicle. And in Mr. Bossi's submission, it makes no reference whatsoever to the content of that statutory provision, and instead makes those statements, as Madam Chair read, related to ill-defined and highly inflammatory concepts in law. So I think I will leave it at that and ask if you have any questions.
Do you have any questions for Mr. Aronoff?
Not any that will speed the process.
You want to begin? Let's see. Okay. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad E. Bossy against Secretary of State Jocelyn Benson on January 2nd, 2024 are not factual and sufficiently clear because they don't establish fact. Their conjecture, their opinion.
I'll second that.
All in favor?
Aye.
Motion carries.
Thank you.
Mr. Aronoff. The next item on the agenda is a motion to recall Attorney General Nessel. The reason printed on the petition by this is by Mr. Chad Bossy. Michigan Attorney General Dana Nessel has failed to protect the citizens of Michigan by allowing vague and discriminatory statutes that have similarities to slave licenses, black code, and disproportionately affect people with disabilities, low-income individuals, communities, and areas with poor public transportation options. The Attorney General has neglected to enforce the separation of powers clause as the executive branch has multiple offices that executive branch, legislative, and judicial functions acting as prosecutor and adjudicator. Mr. Liedl has a question to speak to this issue, and Mr. Liedl has presented us with a very extensive position letter.
Thank you, Madam Chair and members. I won't rehash the lengthy letter. I do want to note a couple of things. First, because this issue actually also affects my client, I do want to reiterate that I do agree with the arguments, the legal arguments that you heard from Mr. Trubilcock about the eligibility of even seek to recall a statewide official in Michigan. I want to share my thoughts. I'll keep them brief on this. I think I can add some distinctions to what you heard from Mr. Trubilcock. Under Michigan law, our Constitution and election law, it's clear who can recall a statewide official. Well, someone who is registered, qualified, and resides in this state. This board has information indicating that Mr. Bossy is not registered, qualified, and residing in the state. Mr. Trubilcock is a member of the bar and officer of the court. He submitted documentation to your staff at the direct indicating that Mr. Bossy indeed resides in California and is registered there. I don't believe you're permitted to be registered. You may be permitted to be registered, but I don't believe you're actually authorized to perform the functions of a registered and qualified elector in multiple states at the same time. And this concerns me with regard to the integrity of our election process. And I'm not an election conspiracy theorist. Mr. Bossy had never been a resident of Michigan and never registered to vote in here. What would this board and this bureau do? You would not process the recall petition. The recall petition would be a nullity under Michigan law because it wasn't submitted by a registered and qualified elector of this state who resides in this state. Okay? Well, let's say Mr. Bossy has been, but since the time he submitted, he's dead. Okay? Well, he may be on the voter registration rolls, but he's not a qualified voter, and he may be interred in this state, but he doesn't reside in this state. That petition should be a nullity. We permit voters in this state to register at 17, even though they may not yet be qualified electors. So you as a registered voter, and the process that your elections director described would forward that recall petition to you because they're, quote, registered. They're not qualified to recall anyone in that circumstance. So to assure that the board are complying with the law and assuring that you are exercising your duty to faithfully enforce the Constitution and the election law, it requires action beyond just simply determining whether someone who may appear on the registration rolls. And that's my concern with the chair's legal argument that she presented. Yes, Mr. Bossi may be registered here, but there appears to be evidence that he is registered in California and elected in California. Well, does that mean in addition to taking this function as a registered and qualified elector in recalling a state official, he can do others? We have a presidential primary pending. He's on the voter rolls. Are we going to permit Mr. Bossi to vote in the Michigan presidential primary, where he also does the same in California? The inquiry really should go beyond whether someone's currently appears on the voter registration rolls. That is not enough to determine whether or not a petition submitted by an individual meets the constitutional and legal requirements. And so it's my position in this instance that the petition submitted by Mr. Bossi does not appear to be. Otherwise, you could have a situation for multiple years where he can continue to submit petitions here because he appears on the voter rolls, even though he may not be qualified. He can do the same thing in California or any other state that he may move to. Sure, we have folks that register and may temporarily reside somewhere else. My parents reside in Florida from January to April. They don't register to vote in Florida. They may not agree with Governor DeSantis, but they have no legal authority to seek his recall in Florida. And they maintain their voter registration here. That does not appear to be the case with Mr. Bossi, who appears to in another state. So I would urge both the board to reconsider its position in this instance. I think you have to look beyond whether or not someone is merely registered. Because if someone is registered but not qualified and residing in the state, the matter before you is a nullity. What you have done in acting upon Mr. Bossi's petitions to seeking to recall the governor and the secretary of state is confirm that you do believe it is a valid recall petition, because you've taken the next step to determine whether the reasons for recall are of sufficient clarity and factual. So that's my legal concern. That's my disagreement with the chairs of the board to do so. I would also urge, for the sake of the integrity of our voter rolls, that when the Bureau of Elections has clear indication from the officer of a court that someone is not registered to vote, that the Bureau is pretty proactive in inquiring with the other state to prevent someone like Mr. Bossi from taking the full actions of a registered elector and potentially even voting in a primary election. We have a presidential primary election occurring now. Those are my concerns as a lawyer on this matter. And I'll move on to the...
I need to respond to some of the insinuations that are being made by our election system, with all due respect to Mr. Levino. First of all, if indeed Mr. Bossi ends up not being a qualified elector for purposes of submitting this recall petition, there is legal recourse, even if it's not within this board, that a concerned individual would take. Regarding the suggestion that someone could vote in multiple states without consequences, that's simply not the case. When you vote, you create a permanent record that you have voted. So if Mr. Bossi or anyone else who's not a qualified elector signs an application of perjury that they're eligible to vote in Michigan and they are not, they can be prosecuted, and people have been prosecuted for this in Michigan and other states. There is a suggestion that the Bureau of Elections is not proactive when it receives information about potential ineligible voters. That's not accurate, and it does not matter, with all due respect to lawyers. It doesn't matter whether the person raising the information is a lawyer. It matters where the information came from. Namely, did it come from an election authority, or did it come from an individual voter, or did it come from another individual who is neither one of those things? Our election law, which we are bound to follow, indicates that when an individual believes that another individual is not registered to vote, the way that information is presented is to the clerk of the jurisdiction, not to the Bureau of Elections. So Section 512, 168.512 specifies that if an individual believes that another individual is not qualified, an individual of that jurisdiction, in this case Albion, could go to the clerk, not say they appear to not live here, but actually say, I am swearing in this notarized affidavit that this person is not a resident, and here's why. So that's the process to follow if you believe that another elector is not eligible. In terms of what the state does, the state's role in maintaining our voter list is not individualized challenges. As noted, those are handled by the clerks. Rather, what we do is a much more efficient, large-scale list maintenance effort by which we get information about voters who have registered in other states on lists. Again, as I explained before, when there is a large list of voters with names, not signatures, we follow the National Voter Registration Act process. We also utilize showing the driver's licenses out of state on a systematic level. And we also, along with clerks, utilize returned election mail to maintain the voter list. If you go to michigan.gov/vote, you can read all about the process by which we identify these voters. There's about 500,000 people right now who are registered to vote who've been identified through this process and will be canceled in accordance with state and federal law. But if an individual wants something to move faster and they believe that another individual in their jurisdiction should be canceled more quickly, they can follow the process under 512.
Thank you, that's very helpful.
Yep. Respectfully, with regard to the director's statement, my argument was not that this would permit Mr. Bassi to vote in 2 states. My argument was that because someone is registered to vote, that does not mean that they should be permitted to then take other actions that are limited to qualified electors who are not, that are also residents of the state. Clearly, we have, in this instance, it is for Mr. Bassi, he may appear on the registration rolls. The procedures under federal law may not permit him to be immediately removed from the registration rolls. But that doesn't mean he can take other actions as a qualified elector who resides in the state. He can't vote. He can't sign nominating petitions. He couldn't sign the recall petition itself legally under Michigan law, even though he appears on the voter registration rolls. He couldn't take other functions that registered voters in the state may take. Why is it that is he being allowed to take an action that is limited under state law only to qualified and registered electors? And I understand the procedures and the responsibilities of state and local elected officials. My concern as an attorney, when the State Bureau of Elections has information that pretty clearly indicates from a reliable source who can't provide incorrect information to the Bureau under the rules of professional conduct, that instead of relying upon federal procedures and saying that's someone else's responsibility, pick up the phone and call the local clerk, send the information to the local clerk, confirm the information with another state so that we don't have any questions about whether someone who is not permitted to take action as a qualified elector residing in the state is someone permitted under state law to take action as a qualified elector and resident in the state. With that, I'll move to the reasons for recall included in the petition. The position of the Bureau and the board appears clear on this issue. The reasons for recall should be rejected because they're not factual or stated in a factual manner. There's a lot of conjecture or personal opinion that does not constitute facts under the election law or the relevant case law. The reasons for recall submitted against the Attorney General also aren't sufficiently clear. They failed to clearly identify the conduct of the Attorney General, not conduct by others, that are the basis for the recall. And then lastly, by objective measures included in the submission to the board by various educational and scientific measures, the proposed recall language is not readable. It's not clear by all measures. And for those reasons, I'd ask the board to reject this recall provision and would be happy to answer any questions.
Any questions? we have a motion?
I'll do this one, but stating that I still remain convinced that Mr. Bossi is not a qualified elector, and that accepting these is as eligible is a mistake that I think we probably will be coming back to at some point.
Member Don, do you mind if I ask a question before you make that motion?
Sure.
Okay. This is to the chair and the bureau director. Would it be ruled out of order for us to make a motion to investigate the status of Mr. Bossi? I'm not making it, I'm asking. Would it be ruled out of order for us to, as a board, given the documents that we've been given today, would that be ruled out of order? And I guess I should look at our legal representation as well.
Mr. Grill?
I think I would need some time to look into the question of whether it is out of order or not. I do know, in general, the board's investigatory capacities are somewhat restricted. I think that would be something I would also have to look into.
Just asking the question.
So Mr. Grill has answered the question.
Yeah, it's fine.
Do we have a motion with regard to the clarity of the petition submitted by Mr. Bossi?
Indeed. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Chad E. Bossi against Attorney General Dana Nessel on January 2nd, 2024 are not factual and sufficiently clear because it is rife with opinion and conjecture and does not meet the standard or sufficiently clear.
I will support that motion.
All in favor?
Aye.
Motion carries. And the petition
Thank you.
to recall Attorney General Nessel is rejected. Yeah. It is 11:15. We've been in session for an hour and a quarter. We're going to take a 5-minute, maybe 10-minute recess. Knowing how recess is always
It's a blast. It's a blast. It's just like Rick roaring good time. It's a Rick roaring good time.
It's like quite a while till we get to her, quite a while.
I think there's even like a question. Why
So
Snap this to your lapel.
Is this on the recall proceedings or on the Axe My Tax stuff that's coming up?
Oh, hey, whatever you want to.
I'll stick to the proceedings earlier.
Awesome. This bar just goes in your pocket. All right. Just have you, yeah, everything's good. Just want the camera to go right here, down on it. Awesome. Let's just do a quick sound test. Can I have you count to 5?
1, 2, 3, 4, 5.
All right. And if you want to look just right at me for the interview, that'd be perfect. All right. Can I have you start by saying and spelling your first and last name and tell us your title?
Jeff Aronoff, A-R-O-N. I'm a principal at Miller Canfield, and I was appearing today on behalf of Secretary Benson.
Awesome. So what are your thoughts on the proceedings here today?
I think they were fairly straightforward questions. These were easy decisions for the board in terms of dismissing the 3 petitions from Mr. Bossi. I think this question about his overall eligible elector to submit petitions in the first place is one that the board will have to grapple with.
Yeah, and I guess just playing off that, it seems like this guy is just like being really, I guess, problematic to the cause, like putting all these obstacles or kind of getting in the gumming up the thing, I guess, submitting these petitions. Why, how can that be taken care of? Or I guess, why is that such a big deal?
I think the state and the board in particular have a balance to strike, right? There needs to be a certain tolerance for people being able to state a position, even if it's distasteful or a bit of a nuisance, but there's certain rights that need to be protected. However, we can't have people abusing the system, which would then in turn infringe on others' rights to use the system to exercise their basic kind of democratic participation rights.
Awesome. And obviously you argued against the validity of the petitions, or the petitions, right? I guess, can you talk about what your thoughts are on those to start with?
Yeah, these were, as I said, very straightforward arguments. The petitions were just rife with all sorts of non-factual, inflammatory statements that have no place in the election petition process. There are many forums to make those, but they're not properly part of a recall petition.
Awesome. Thank you so much. Those are all the questions I had. If there's anything you want people to know or that I missed, that would be the time. All right. Thank you so much for your time. Yes.
All right, have a great day. Thank you.
Hopefully you don't see too much in the back for that.
I was over there and I saw you were pointing at the lawyer and I'm like, oh shoot. And I tried to give you some.
No, you were good, man. I literally, because I was walking and I just I see your interview and I just go.